What's up, everybody? Welcome into another episode of The Lawyer You Know. And today we have another wild day in court as Mr. Alessi cross-examined the Cellbrite expert from the Commonwealth. We also started to hear from Jen McCabe. It was an interesting start, but the end of the day was potentially the most confusing / exciting / unreal part for an unreal case and an unreal trial. I couldn't believe the rule Judge Cannoni cited in what her proposition or argument or scolding was to the defense. And Alessi's response shut her down pretty quickly for her to say, you're going to win anyway. So we will get to that at the end of the video. That's probably the part I'm most excited about, but we're going to begin with Alessi's cross of the expert, and we will get through the entire day of this trial. So my computer's being a little glitchy. I don't know why here, but we have Mr. Whiffen, who is the Cellbrite expert, back on the stand. And Mr. Alessi just began his cross yesterday. He didn't really get to dig in until today. And we knew he was going to dig in. It's no surprise here. Was it a surprise to the jury? Maybe. We knew there was going to be a lot of technical issues. There was going to be a lot of things that he picked out. A lot of reasonable doubt. A couple of times he asked Mr. Whiffen, well, that means it's not for sure, right? That could be doubtful. It could be even a reasonable doubt. He would ask him, and Mr. Whiffen really had no choice but to agree. People say Alessi or Alessi. I think it's Alessi, but I don't know. Are you making fun of Judge Cannoni? I don't know. I don't pay attention. I listen to it on 2.5 times speed now, so sometimes I don't even catch mispronunciations. But it was really important to poke holes in this witness's testimony because I thought he did a good job on direct. I know some people disagreed with me. I thought he made some of the points so much clearer than he did trial one. And I thought Hank Brennan did a good job to highlight when he would say something that was important to the case, whether it was a Google search, a text message, a deletion, healthcare data, aka health data, the temperature of the phone. I thought they did a pretty good presentation on direct. So it was important on cross for them to say, not so fast. There are issues. It's not as clean and pretty as you want it to be. And that's exactly what Alessi did. First, he starts the report in the timeline. And he's kind of comparing some differences. You didn't put this in the timeline, but it is in the report. And we're going to talk somewhat about the location data and how accurate really is it.
Why the accuracy is reduced at this point, correct? Correct. Thank you. This could include reasons such as the device entered a building covered area, the result of weather conditions, geography, poor connectivity, or interference, to name a few. So those are the reasons you gave, which could contribute to some low accuracy, correct? Correct. And interesting,
right before this, he started talking about, well, it's pretty clear his phone could have been in the house, right? And he's like, well, if you look at the low accuracy data, but I didn't include low accuracy data in my report. It's like, okay, some of the reasons you said it could be low accuracy is because it could literally be inside under a roof or in a garage, right? I thought this was great.
Very first reason you gave is that the device could be entering a building or covered area. And that phraseology could include a house, correct? Correct. It could include a garage attached to the house, correct? Correct. And it could include the house at 34 Fairview, and it could include the garage attached to the house at 34 Fairview, because both of those are buildings or covered areas, correct? Correct. Then you go on in the next paragraph to say it is known that the device was not being used at this time. It is this time that include that 1237, 12-minute range, 1225 to 1237.
Yes, it was not being used for location purposes.
Right. So that's another reason why, right, the accuracy could be a little bit on the lower side.
Correct.
Now, the next paragraph says, at 12:38:13, when the device begins recording higher, and that's relative to what it was recording before. It's not that it's high, but it's higher than what it was just moments before.
Correct.
The data centers on a...
So he's setting this up before he puts the picture up. That is the big circles, the black and the white circle, where the outer edge of the circle, where he could be anywhere in that circle, is clearly inside 34 Fairview. Does it prove beyond a reasonable doubt John O'Keefe was inside 34 Fairview? Absolutely not. It may not even prove it by the greater weight of the evidence. But what he's doing here is setting this up where Mr. Whiffen, everything you testified about that, oh, this is where he was, the high accuracy data, it's not really that accurate, right? And there's all these reasons for it. And frankly, the data shows he could have even been inside the house. And that's really important to me because from my perspective, if you're going to use these things to prove beyond a reasonable doubt, they better be accurate. We don't want to just throw stuff against the wall and be like, close enough, let's convict defendants. We know how many defendants have gotten their cases looked at again and reopened and reinvestigated because of the DNA evidence. So when we have technology and advancements, we need to make sure it's reliable before we really start using it. And that was what Alessi was doing here. Then he goes to some of the GPS data jumping around. So we'll jump ahead a little bit here.
Big white circle. Have I done that correctly?
Yes, correct.
Thank you, sir. The next paragraph. Over the next few hours, the GPS coordinate and the associated accuracy radius jumps around numerous times between the house and the road. Did I read that correct?
Correct.
In their
a very skillful working through cross by Alessi to put this on the screen and highlight it where the jury can see it and get the expert to agree and confirm. It was jumping numerous times between the house and the road. Does that mean he was in the house? Not necessarily. Does that mean he was in the road? Not necessarily. But what does it prove? Where does it prove he was beyond a reasonable doubt? I think if you ask 10 people, you might get 10 different answers. That's usually not good for the Commonwealth. Cheryl, why did the feds get involved in this case? Thanks for all you do, Peter. Keep being you. They investigated the investigation. It's about as good as I can tell you because we don't have like some official report from them, but they looked into the investigation into Karen Reed, into the investigators that investigated Karen Reed. Kat, redirect was so long. Is that a strategy? Not usually. It's not like he was trying to get to the end of the day or anything like that. I think he just had a lot to get to. And sometimes when a lot of holes are poked, you've got to go fill all those holes. You've got to extinguish every reasonable doubt if you are a prosecutor. You have to. It's your job.
Therefore, over the next few hours, according to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes.
Based on the low accuracy information, yes. So he keeps saying that. He keeps saying high accuracy versus low accuracy. What does that mean to you? If an expert gets up and says high accuracy said he's in the road, low accuracy said he's in the house, and the defense is arguing, well, the data says he could be in the road or he could be in the house, right? And then they have other things to pile on top, obviously. So what would that mean to you? That distinction of high accuracy versus low accuracy, is that enough for you to be like, okay, I'm with this expert, I get it, I'm picking up what he's putting down?
So you then state, while location data from this data source, cache SQLite, is usually able to identify the location of the device with a high degree of accuracy and reliability, these records are so close that making a distinction between the device's actual location on the front garden is impossible, correct?
Correct.
Your words.
Making a distinction where this phone is in the front garden is impossible. His own words.
Actual location on the front garden is impossible, correct?
Correct.
Your words, impossible.
Correct.
Did you provide any of the information in that paragraph in your timeline or to the jury in your direct testimony yesterday?
Not in the PowerPoint, no.
And that was a good question he asked over and over again. When he would get to a problem, an inaccuracy, a distinction, something that he said X, Y, and Z, that was bad for them, obviously. You didn't talk about that on direct, did you? Making it look like he's hiding something from the jury, something the prosecutors are going to have to deal with, and something the prosecutors are absolutely going to do to the defense witnesses as well. But Alessi methodically went through. There were times, right? I listened to it on fast speed, right? It's not even at 1.5 speed. I listened on 2.5 speed. So it doesn't sound as slow and boring, but there are certain parts where I do understand if some people think Alessi's a little bit slower with it and maybe the jury's getting bored. From my perspective, he's methodically setting up a point, putting all this found like, This is your report. You try to be accurate in your report. This is the data you got. This is the data you use to make your expert opinion. And then you say this, right? This isn't your report. All that data, all that education, and this is what you said in your report, but you didn't say it to the jury, did you? So I think he's setting them up and knocking them down methodically. Okay, next I want to just show you kind of how he gets to this point. And we're looking at I think you guys can see that the white circle is, you can see it's inside 34 Fairview. The black circle is not. They want to focus on the black circle. The Commonwealth, obviously they being the defense, wants to focus on the white circle because you can be inside the house there. And, that's the distinction Alessi was making at this point in Cross. Then I thought this was great. There's some things that are new this trial, and we're going to learn. One of the things we learned is the new accident reconstruction team or person used Whiffen's data and their report. And Whiffen, I believe, confirmed he reviewed their report and their PowerPoint or report/PowerPoint. Then we get to at 1:32:16, 36 steps are taken. He focused on this for a while. To me, again, you guys tell me, let me know what's a big deal, what's not. What is really pushing you so far this trial? If you think she's guilty, what's proving to you that she's guilty? If you think she's not guilty, what's proving you that? If you think she's going to be proven innocent factually, what's getting you there? 36 steps, 85 feet or whatever at 12:32 to 12:33. That's a big one because we know very shortly after she's connecting to John O'Keefe's Wi-Fi, she being Karen Reed. So let's listen to a little bit of this back and forth.
Do you recall writing in your March 2025 report the following? The final health activity of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 25.4 meters, again, that 84 feet, according to healthdbsecure.db. Do you recall writing that?
I do.
And you used in your report 36 steps were recorded covering a distance of 25.4 meters or 84 feet, correct?
Correct.
Do you know a trooper named Nicholas Garino?
I'm aware of him, yes.
Are you a little more than aware of him? You've worked with him on this case, haven't you?
He sent me some of the files related to it, but further than that, I've got no relationship with him.
But isn't someone sending you files on a case you're working on, working with a person? Isn't that a fair conclusion?
It could be.
Do you recall reading any reports of Nicholas Garino?
I don't recall reading a report by Nick.
Does that mean you didn't?
And I just want to leave that part in there because he calls him Nick. And then did I keep the part in when he calls him Hank? Where is that? Yeah, okay. That's coming later. But I just thought that was funny after yesterday. Hank Brennan was like, "Oh, Alan, huh? Alan, your BFF, Alan? What is that from? What's up? Nothing much. Your BFF, Jan? What is that from? Like a famous commercial or something? I'm sure I'm butchering it, but that's kind of what it reminded me of. Nikki said, I have to give Whiffen credit. He came off so much more reliable than season one Garino. Garino basically stonewalled the defense. I thought Whiffen seemed pretty reliable. I think that the cell phone data, just like the last comment said, is never perfect. And because we're dealing with things that are so close together, this to me, it's okay if you guys disagree. And I get it. Some of you will disagree and say, no way. Like I saw Ben comment. I think some other people comment like he's absolutely in the yard. He's not in the house. I get that. And if that's enough for you, good. And that's what they're trying to do. To me, cell phone data this close with how inaccurate I believe it to be, even from his testimony, it just would never prove an exact location of somebody. If it was like in, was it the YNW Melly case? It's like, you're talking about like 20 miles away. Sure. Even in the Adelson case, did you drive by the house or did you actually go to the house? in those situations, I think it can be way more helpful than we're talking about 70 feet difference. It just is not that accurate to me. Not that accurate. Okay, what do we have next? He shows him the report. Did Nick tell you how far the flagpole was to the front door? I thought that was funny that Alessi even started calling him Nick when referencing Guarino to Ian Whiffen. And he's like, no, maybe. Was it 72 feet? Maybe. 24.9 meters, that's 84 feet, right? That's longer than 72 feet, right? I put banger on that. I hope that the use of meters and Celsius was not to confuse the jury. I would assume it's just because that's what Whiffen uses in his, where he's from, even though that's not what we do in America, which I think is kind of interesting. Because I didn't know 25 meters was 25.9 meters or whatever it was 86 feet or whatever the numbers were. I didn't know that calculation in my head unless Alessi would have told me. Then they go to the phone temperature, how during his test, it would drop like 30 degrees in 13 minutes. Yet from 12:37 a.m. to 1:36, it only dropped 22 degrees outside. His experiment in the freezer, it was 50 degrees in 15 minutes, which is much different than what happened to John O'Keefe. And they go back and forth on the fact that you did these tests which don't line up with what you're trying to say that they say. And we're going to listen to a little bit of that exchange.
Correct.
Do you know what the temperature was in Canton in January 29th, 2022?
I do not know.
Don't you think that that would be an important piece of information in analyzing where the phone of John O'Keefe was on the morning of January 29th?
I didn't think it was.
So you didn't think it was important, even though you issued a report discussing the temperature of the iPhone, and you did 2 test scenarios, one in a freezer, one in an ambient temperature of slightly above 33 degrees, and you didn't think it important to take the final step to see whether there was anything to be gained from that comparison to determine where that phone was located?
My testing proved that the battery temperature is affected by ambient temperature. My report shows the data that was on the device. I also don't know the condition that the phone was found in, whether it was in a case, whether it was in a pocket. So to me,
I have a question. Why didn't you ask? You talked to Nick and Hank. Why didn't you ask? What condition was it found in? Where was it found? How was it found? Who found it? What'd they do with it? Seems like things you could have got the answer to, right? Definitely seems like that.
the ambient temperature in Canton at the time wasn't particularly relevant. I just wanted to show what data the device had recorded.
The information that you create from your digital forensics analysis, including everything that's in the slide in your report, including battery. I'll go back to the question. In digital forensics, you work with law enforcement often, correct?
Correct.
And you work in law enforcement in investigating cases, do you not?
Yes.
And so oftentimes, the law enforcement is using your digital forensics information to help them solve cases, correct?
Correct.
You didn't suggest to anybody on law enforcement that they might want to take a look at this temperature information to assist in determining where this phone could have been by the temperature? You never raised that with them?
I did not.
And do you know?
That just makes me seem like, what are we doing? Because I thought Hank Brennan was going to use this as some big part of the evidence. And BB, I don't disagree. It was kind of confusing. And even later on, they go into, it's like, at 6:06 a.m., the temperature only dropped 7 degrees in 4 hours. I'm like, okay, what does that mean? Like, what does it mean? Does it mean he was inside the house? Does it mean he was laying on top of it? Does it mean that he was moved before that? I don't really get what this is trying to prove. Both sides, of course, are going to tell me, this is my left hand, this is my right hand. I get it, right? That's what happens in trials sometimes. It's not proving anything to me. I'll just say that. I would say the temperature data has done almost nothing for me. Let me know if you disagree. Grace Bay said the effective temperature on battery is well studied. To prove what? To prove what? Right? That's what I would ask. I'm not disagreeing with you, by the way. To prove what? What am I supposed to learn from this? That's what I want to know. Netwoman says, wouldn't you say that this expert testimony goes for the Commonwealth, i.e. Hank, as he said, I don't remember added motions by the defense for this? Wouldn't you say that this expert testimony goes for the Commonwealth, i.e. Hank? Meaning, of course, yes, this is a Commonwealth expert, but he tried to ask him certain questions like, well, it would be bad if somebody was giving you things that would color your testimony. It's like, okay, like to try to act like it's not hired by you and this guy doesn't work for law enforcement 80% of the time and this guy didn't used to be a cop, whatever. And it just depends on what a jury thinks, right? I may think something different than you. Is he biased? People say all experts are biased. Fine. They're all paid to do a job and they're all picked by one side. So we know what their opinion is going to be. But I don't think every expert just gets up there and lies. I don't think they put their licenses and their education, experience, and reputation on the line to lie. I think experts see it differently. And usually you pick the expert that sees it the way you see it, right? Is it appropriate for Bev to prompt the prosecution saying about ARCCA, I'm going to allow what I expect to be a very robust cross-examination? Sure, she can say that, but it means absolutely nothing. We will get to more of this later. Don't you worry. Azam, hi, Lawyer You Know fam, missed yesterday. Peter, the defense didn't mention ARCCA in opening, right? How could they introduce them during trial in their case in chief? So they didn't mention ARCCA by name, but they absolutely mentioned experts in science and math. They won't introduce them outside of that. Tanya said, I know motive doesn't have to be proved. That's correct. But to me, she's the only one with motive and lead up in texts and calls. I will tell you, jurors think like this. They want motive. They like motive. They want to try to find motive. They try to figure out if somebody did this, why did they do this? So that could be something they're thinking, who else has motive? And I think the defense is trying to develop that. Bella's mom, that's funny, says, Peter, for the win on Twitter today, you dunked on our better. I'll allow it. Keep on sharing your magic 8-ball. Not Nostradamus, not a fortune teller, not even that lucky. Bettero said the same thing, right? That's what she was going to say. And I'll tell you right now, I hate Twitter arguments. I almost never do it. Bettero is my favorite person to argue with on Twitter right now. And it's not even an argument, by the way. I like how he disagrees, right? He's like, how can you see it like that? I see it like this. And I'm like, well, this is where I'm coming from. And this is why I'm doing it. To me, that's what it's supposed to be about. If America was like that, I think we'd all be better. We'd all be better off. We'd learn more. We'd be able to work together more. I have a lot of respect for Bettero. I think he's a real lawyer and a good lawyer. And so I did not dunk on anybody, and I will disagree with him anytime on Twitter. I rather enjoy it. You guys, some of you say, Peter, that's so mean when you disagree with your dad. Me and my dad disagree all the time. I think he's the best lawyer in the world, best lawyer I know. I'm still going to disagree with him. It doesn't mean I agree with everything he says. All right, let's get back to this.
Know whether any law enforcement person was aware that you had done all this temperature analysis?
It was in my report.
So you create a report as part of this case, and you deem the temperature important enough to do 2 test scenarios, important enough to put it in a slide presentation to this jury. Yet there's no discussion of that between you and any member of law enforcement as to what it means?
The details were provided in my report, and there was discussions, but it never came up as to say what was the temperature in Canton that night.
Oh, so there were discussions?
Not with law enforcement.
Oh, who
as part of my preparations for trial.
Oh, tell me about who you discussed this temperature information.
Alessi's like, oh, there's more. Why don't you tell me who you did talk about this with then?
With?
It was with Hank.
You're hesitating, and I can't information with.
By the way, this is on sped up speed, so he's like, Hank, and he does hesitate. Alessi's right.
It was with Hank.
You're hesitating, and I can't hear you. Who did you discuss
with
it
Hank?
Excuse me?
With Mr. Brennan.
Attorney Brennan?
Yes.
You discussed temperature with Prosecutor Brennan?
It was in my report.
It was in your report, but you said you discussed. Which is it?
It's in my report, and the discussion was that it is in my report. I'm not in a position to suggest that investigations take place and change based on my report findings.
Oh, sir, I'm not suggesting what you just stated. I'm just trying to get information about, you mentioned the verb discuss. Didn't you, in your answer moments ago?
Yes.
Isn't discuss a verbal thing? It's not a written thing?
That tells you, be very careful the words you use to Mr. Alessi. Because as any good lawyer does, and I talk about this all the time, you're doing 10 things at once. You better be listening while you're asking questions. That's one of the things that is taught in trial advocacy class when you're on mock trial and you're an older student talking to a younger student or a lawyer who's helping out students in the trial advocacy class. Do not just ask your questions. Same thing in a deposition. Do not just go down your question, and don't listen to the answer. You better listen to the answer because you never know when nuggets are going to come in the answer. And Alessi, words are important. He's like, you said verbal communication, not written. Those two things are different. So tell me a little bit more about that.
It was discussed in preparation for trial, yes.
Oh, so there was a discussion, a verbal discussion with Attorney Brennan about temperature in your preparation for trial.
Yes.
Was there any?
I also think a good lawyer looks ahead. And this rigorous cross-examination that Judge Cannone is going to allow with ARCCA, let's just make sure everybody understands. You're talking to Hank, right? Your buddy Hank. You're talking to him. You guys are discussing stuff. You're telling him what you're going to testify about. You're giving him your PowerPoint, which is fine. But Hank Brennan's not going to be able to get up there and act like the defense is doing something that no defense attorney has ever done in any case. And it's so nefarious with these ARCCA experts, and they're totally just doing everything they can, throwing caution to the wind to make sure their side wins.
Interest at all as to what this could actually mean for the potential location of Mr. O'Keefe's phone on these very important time periods in January 29th that might assist to determine at various times whether Mr. O'Keefe is in a covered building based upon the temperature rather than outside in a nor'easter on January 29th?
I'm sorry, what was the question now?
Yeah, the question is, was there any discussion about the investigative value of what you had done in determining where that phone could have been on key time periods on the morning of January 29th?
That wasn't part of the discussion, no.
It wasn't part of the discussion. We went through, you may recall in my questioning in your report, where you stated that it was possible that the phone could be inside the house of 34 Fairview based upon that big white circle. You testified that the low accuracy at certain points could be because of it entering a covered building, correct?
Correct.
And you do a temperature experiment to track the very accurate temperature change of an iPhone, and it doesn't match up the actual data with either of your test scenarios, and you don't raise that with anybody.
Sustained. You can ask it differently.
Did you ever put together in any kind of form your test scenario 1, your test scenario 2, and the actual temperature chart of the iPhone of Mr. O'Keefe?
So how do you mean put it together? As in compare the two?
Exactly. Compare the two and reach any conclusions about location, because you spent time, did you not, sir? A lot of time in your reports on location of the phone.
Yes.
But yet, with all that data, all that testing.
You know what, Chris K, it's a good point. What was the relative humidity of the freezer? What was the relative humidity outside at the scene? Does any of this affect anything? Did he test this? I like your dog more, said Peter. How shocked are you that Mr. Whiffen didn't think the temp of the freezer was important? It's like, why are you doing these tests, man? What's the point of these tests if you know nothing matches up with where the phone was? Why even do the test? That's why when I think about this, as well as it seems like some of you, what does this actually prove? What does this actually prove? Grant N said, I don't think robust cross scares the defense. If he behaves like yesterday, the jury will hate him for being that rude. Can I tell you why a robust cross doesn't scare me? You should be able to do robust cross on every witness in every case as a lawyer. And I just looked up robust on dictionary.com. Strong and healthy, vigorous. That should define just about every cross in every case. So to act like you're going to allow it this time, I'll allow it. It's like you should always allow a robust cross. Jarhead said, favorite public defender viewer, tell viewers jury isn't required jury to accept reasonable interpretation of the evidence favorable to Karen. That's why the defense focuses on what is possible. Yeah, so they could look at it a bunch of different ways. And if you're thinking that, I get that. That scenario could have happened. Maybe he was in the house. Maybe the Google search was at 227. If that's reasonable doubt, right? And that's important. But they could also think, nah, that's unreasonable. And then you're working away from it. That's why you have to point out more than just one thing. Peter, I LOL'd when Alessi said, sat right down. Help me get Jen's new angle. Why so detailed? Thoughts on changes AJ might be making on cross tonight? I'm gonna hold this question till we get to McCabe's testimony. If the juror has IT background and thinks that IW's testimony was bogus, can they use their knowledge during deliberation? Yes. They can completely throw it out if they find him not to be credible. In fact, there's a jury instruction that says, if you find a witness to not be credible, you don't have to believe what they say. You don't have to take what they say as evidence. Frankly, you can even give a negative inference and be like, why would the Commonwealth put that guy up? That's not credible. I'm not saying that's happening here, but based on your question, yes, it could happen. Bev's biased beratements Any evidence yet that Karen hit John with her car? I've yet to see that. It's so weird when experts testify to doing intricate tests, yet ignore bigger things like, did you ask what condition it was found in? And like, what was the temperature that night? If you're going to put it in a freezer, why not ask what the temperature was that night? I'm not picking that up. Okay, then they start talking about the hash value. And I know you people can tell me, you tech people can tell me how important that is. He's like, okay, you have an issue with the hash value. He's like, no, I don't. Yes, I do. You didn't tell the jury that. Did you talk to Hank about how you can't guarantee the authentication? You don't know the chain of custody of Jen's phone. That to me didn't quite land awesome. You guys can tell me if you disagree. But what I did love is when they brought up Axiom, the competitor company to Cellbrite, and how that still shows the 2:27 a.m. search, and how Cellbrite has gone back and changed it since the first trial. And Alessi said first trial about 5 times. I was cringing every time till the judge stopped them, called them back up to the bench and was like, stop saying first trial. And then he's like, I mean the first proceeding. You know what I mean? The first proceeding. We'll listen to a little bit of that back and forth here.
As a matter of fact, in the first proceeding in this case, in June of 2024, when you testified under oath, the situation with the forensic tools was Cellbrite Forensics Insights did not show the 2:27:40 a.m. timestamp, but another version of Physical Analyzer did show it, correct?
Correct.
To get him to say correct to that is big. And if I'm a juror, I'm like, whoa. There's another program out there. We've only heard about Cellbrite. Michelle L., I agree. I just don't know that this puts John inside the house. It's a possibility of him being inside the house.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly. You changed it since then.
Yes.
He thought we changed it since then was a great answer to Alessi. Alessi's like, oh, you did, didn't you? You changed it. You changed it. You can put the right emphasis on the different syllables there, and it makes a big difference to the jury. You are the one that changed it. And what did you have to do? You changed it because it used to say this. And that does sound a little sketchy. I think he's got a pretty good explanation for it, but it does sound a little too much of a coinky-dink.
Your company removed it.
Yes.
After the first trial.
Before the first trial.
Well, you removed it from one tool before the first trial, but you didn't remove it from the other Physical Analyzer program, did you?
Up until the following version was released.
No, I'm talking about the time of trial when you were testifying.
I appreciate that. There's some complexities with how we release the software, which resulted in one being released several weeks later and one being released several weeks earlier.
At the time of trial,
yes,
last year in June, when you were testifying under oath, one of the Cellbrite tools showed the timestamp of 2:27:40 a.m., correct?
Correct.
But that timestamp doesn't exist anymore. It doesn't exist today, does it?
Correct.
Cellbrite removed it.
Yes.
Could I see counsel at sidebar for just a minute, please?
That's where she's like, hey, Mr. Alessi, let's not say during the last trial. Mo, this was a tough look. I'm not going to lie. I don't know what it is in Celsius. Is it 0? I don't even know. So I can't really blame him. I'm not an expert. I would have known if I was going to take the stand and testify about this stuff. And I think he may have said 0 today, but I can't even remember. That was a tough look, though. If you're going to be testifying about stuff like this, you need to know that answer. They go back and forth again on this, but I think Alessi made his point that they changed it after the first proceeding because of what happened in this case led them to make that change. So, and guess what? Only they made that change. These other competitors that this expert agreed were reputable companies did not make that change. Then we get to the deletion of the search, and he said, you have some doubt about how that deletion occurred. And he said, yes. And he goes, are those doubts reasonable? Because he gave all the different ways that the deletion could have occurred, accidental, intentional, whatever. Are those doubts reasonable? And he said, Yes. All right, let me see if we have anything else. There's a bunch of starred comments, but I want to get the ones that have to do with Whiffen here. Mildred, so a guy doing the test doesn't know 32 degrees Fahrenheit is the same as 0 degrees Celsius. Yeah, I mean, and you're testifying in America as an expert. I'm not trying to be like, you got to do everything our way, but it's like, if you're going to testify, like the jury, most of the jury is going to be thinking in Fahrenheit, right? And they're going to be thinking in feet, not meters. So let's try to make it easy on the jury, not hard for the jury. Oh, if a juror doesn't know meters versus feet, can they Google it? Same with Fahrenheit versus Celsius. I mean, theoretically, they shouldn't. But that's a question they could ask if they really wanted to ask a question. But it's a perfect point, Nina. Great minds think alike. Brian Walsh is taking notes on Celebrate. A lot of defendants are. I think a lot of defendants are. Did anyone catch Brennan asking, can you say this to a reasonable degree of scientific certainty? And Whiffen said, my opinion aligns with that. So not yes. Sneaky. I did not notice that. All right. Let me see here. Okay. We go with Brennan, and I've been saving this question. Try to keep up with these questions. There's a lot. Where is it? I think it was from Siobhan. Where is your question about? Here it is. Also, Hank Brennan leading. Defense attorney, oops or cheater? Definitely not cheater, but defense attorney, oops, only lasts so long. Okay? Number one, the judge needs to instruct him to stop. It's been too much. Also, it doesn't bother me as much as a lawyer with an expert witness, because the expert should know. The expert shouldn't just say yes to a lawyer. But when it gets to lay witnesses, if you start telling lay witnesses answers, because that's exactly what leading is, the answer is in the question. So, oh, excuse me, beg your pardon, Judge. Let me ask it again this way. It's like, the dog was black, wasn't it? Excuse me, I'm sorry, Judge. What color was the dog? You can't have that on lay witnesses. And I want to bring it up now because he did lead a ton during redirect with Whiffen. The data is the data. Science is the science. I just explained my opinion on it. The battery testing was just to see if it's affected by the temperature outside. It's like, okay. He moved for 20 seconds from 12:31 to 12:32. You don't know where he moved. You just know he moved. I don't get how that fits the Commonwealth's timeline, how they're going to work with that. I thought the directive Whiffen was good. I thought this entire redirect was worthless. I don't think he got anything except for when he got to the demonstration. So he talked about, how Celebrate removed it, why they removed it, how it's the better way. They're the better, doing the better analysis and all the different ways they worked on fixing that. But then we get to the demonstration, which I want to show, and we're going to watch together here. And there are some questions about it. And to me, I actually thought the demonstration landed pretty well. And I was like, okay, I get what he's talking about. That's a good demonstration of how when you search something and the tab stays open and it shows that way. And the defense is going to have to deal with that. I also think it's good to show the demonstration to show you can reproduce that. As the Commonwealth's expert, will the defense be able to reproduce that? That's a question I have.
Without taking longer to do this demonstration. If I go back onto the phone itself, just takes a second to refresh and open up Safari. And I can open up a new tab. What I will just do now is search for the time that we're on now, so 14:10, and hit go. So right now that page is loaded, sure. And I can go back into the database and just hit reload. That will bring the most recent version of the database from the device back onto my computer and show it back in this window in exactly the same way as I was doing a second ago. And you can see right now there's still only 2 records. So the fact that I did a new tab and a new search has had no effect on what I can see. This is different to on previous versions of iOS, where you would already now see a new record with the 1410 search, which I've made. I'm then going to do another search. Hopefully it's going to catch up with me. It's now 1411, so I'll do a search for 1411. Okay, we can see the page is loaded, and I can go back over to this tool and reload the database. We still don't have a new record that shows that a search is being conducted. I'll just take the time to do another little search and just do 1411X. Reload the page again. Still, nothing's appeared. I can even close down Safari, just minimize it into the background, and then bring it back into the foreground by just pressing the Safari icon. I can hit reload again, We still don't have a new record. And I can do a further search for now 1412. 1412 is loaded, and I can reload the page. Still no records present. I can now go into Safari and just close the tab. So now that tab is closed, and I can just prove that. So that tab is now closed. And I can go back over here and reload. And you'll see a new record has appeared. I'm just going to change the time zone just so that this shows accurately, and tell my tool to treat the timestamps as Eastern time. So we look at this particular record. You can see the title is 1412. That's the last item that I searched for. You can see the URL is the google.ca /search 1412. Again, that is the content that I searched for. And then we see this field here, the last viewed timestamp. And the time here still says 1410 because that's the time that I first loaded the tab. The fact that I navigated between, the fact that I minimized and reopened Safari, bears no relevance to this timestamp. It is purely the timestamp that tab was created or brought back into focus.
To an untrained eye, can that?
You guys tell me. I think that was pretty effective. I think that was pretty effective. Yeah, and not Eminem's mom. Seems like it's like all you know is when I open that tab. I could have searched 50 different things under that tab. You don't know what I searched when. I mean, that demonstration seems effective. That's definitely something the defense is going to have to deal with, and we'll hear how Alessi deals with it when he gets to recross him in a second. Ashley asked, why could Brennan present the demo on redirect, though? Seems like he would have had to do that on direct. They asked questions about it, so this is still responding to the defense's cross questions on this Google search, how it could happen, if it was at this time or that time, how Cellbrite changed it, why is it different showing now? Axiom didn't have it. All those questions give enough leeway to be able to do something like this on redirect. Peter, which defense attorney is most effective overall in your opinion? Honestly, it's a pretty good team where they all have different strengths. That's my opinion. I really think Alessi does a better cross of certain witnesses than Jackson. Jackson's style is my favorite, like I said, but Yannetti seems like the nicest guy out of all. I don't know. It's like they all have strengths. And I'll tell you what, they all look at Elizabeth Little quite a bit throughout the trial. They're like, can I get the answer? Thank you. It's like, hold on a second. I have to check with Miss Little. Okay, thank you. So they all have their strengths. They're all necessary. And I think they're a good team at this point. They're a good team at this point.
Development of a timestamp become confusing?
Yes, the name last viewed time clearly has implications.
Corey, I did not know that. I know they mentioned, his program. I didn't know that's what this was. I was wondering this looks like an old computer. It doesn't look like any computer I've seen. So this was his program, which that would have been a good question on cross.
That would make you believe that it was the time that the page was last viewed. It's a very simple test that I just demonstrated to prove that that's not the case.
Is there any other reason?
Sabina, I tended to agree, but I am not a computer guy, so I don't know. I'm not an IT guy.
Cellbrite removed that process as timestamp, other than to clarify that issue?
Objection, Your Honor.
No, I'll allow it.
Purely because we determined it was unreliable to use as a time that the page was last viewed.
If an examiner simply made a report from Axiom or Cellbrite or another software, but didn't have the time or skill to actually go into the data, could they be easily confused by this?
Yes, the way that Cellbrite provided this information showed as last viewed timestamp. The way that Axiom provides this data is called last interaction time. So there is some leeway there to misunderstand it less from Axiom because it's talking about tab interaction rather than a web page that was last viewed.
Thank you. I have no further questions.
All right, thank you. The lights on, please. Mr. Alessi?
I thought that was a pretty good end to redirect, personally. Christy, who closes tabs? That's what I saw this comment. I want to go look at how many tabs I've opened. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33. I have over 50 tabs open, just like scrolling on my phone. So not me. Do we know how Karen is paying for her lawyers? Are they doing it pro bono? They're billing. They said they're not collecting, I guess. I'm not positive. I haven't really gotten into that a ton. McMuffin, I'm curious, as a lawyer, does your trust in Cellbrite's data collection change in light of Whiffen's testimony that they changed data? It doesn't make me think it's unreliable now, but it does make me think, like, what's it actually going to prove? Because it used to stand for the timestamps, right? That was one of the really important things. Now I think it's going to be harder to use generally. Here comes the
Good
recross.
afternoon, and hello again, Mr. Whiffen.
Good afternoon.
Magnet Forensics Axiom still shows a 2:27:40 a.m. timestamp on its forensic tool, correct?
Correct.
By the way, yes, that's Alessi sped up.
And Magnet Forensic is a reliable forensic tool company, correct?
As reliable as they come, yes.
The demonstration that you just performed, when did you create it?
The demonstration?
What you just,
Like literally just now as I was doing it live.
so you
Is how
just
you mean?
created the demonstration now live on the stand?
That particular demonstration, yes.
So that demonstration, therefore, was created after Celebrite removed the 2:27:40 timestamp from all of its tool programs, correct?
No, incorrect. I mean, that demonstration I just provided was right now, it was live. Initially, when I did these tests, I did the same kind of experiment, the same type of testing back in late 2023, I believe. And after I did those tests and used that research, that is when Celebrite removed the timestamp.
Maybe my question wasn't clear. Let me
Yes.
see if I can rephrase it. The demonstration that you just gave, when did you prepare it? The demonstration, not just the demonstration that you just showed on the screen. When did you create that demonstration on your computer?
Again, I've been doing this demonstration for 2 years.
My question, again, is
I truly don't think Whiffen understands what he's asking, but Alessi is trying to make the point that, of course, it's going to show this way because you changed the program to make sure it shows this way because of this trial. The first trial, as he said.
the demonstration you just gave.
Yes.
When was the last time you altered that demonstration?
Other than to use different search terms, it's the same demonstration.
I'll try to differ.
Yes, please.
When was the last time you altered in any way the demonstration you just gave?
Right now.
So you altered it right.
That's his point. That's his point. Gorgeous George. Yes. IDK, my BFF Jill. Yes. That was it. Michelle, touche. Once again, touche. Good point.
Right now, and that alteration was made after Celebrite had removed the 2:27:40 a.m. timestamp from its programs, correct?
Yes. Okay.
Thank you. No further questions, Your Honor.
Thank you.
All right. And that's the end of Mr. Whiffen. Then we get Jen McCabe. She's back. And I've got some comments here that you guys have made on her that we're going to look at before we listen to her testimony. Richard White says, Jen McCabe, crocodile tears, yes or no? What are we thinking? That is up to you, the chat, to determine. What do you guys think? Lazy people don't close or delete. LOL. There's some really funny ones. IDK, my BFF Jill, and then Chris, of course. Every time I read one of his sarcastic chats in the middle, I'm just laughing in the middle of trying to watch a serious trial. So I always hope it doesn't happen at the wrong moment where somebody says something very serious. Jen must have taken some acting classes. So I took this to believe that you thought round 2 was better than round 1. I tend to agree. I tend to agree that she was better this time around. And Siobhan said, why is she so detailed this time? Will Alan Jackson be making changes to Cross? I'm sure he will, but I think he's going to hit a lot of the same points he did too. And we're going to wait to break down his Cross until he does that tomorrow. Was there any more, Jen? Al Dente said, will you do a show with your dad and Betero? I think it would be like a 6-hour show if I did that. Jordan, why can't the jury know there was another trial? Feels like the defense should be able to let them know the prosecution failed. So Jordan, you've answered your own question. That's why we meaning lawyers, don't want the jury to think things that they shouldn't think that are not relevant to proving this case based on information that's not irrelevant evidence, right? So we don't want the jury thinking, oh, this is trial number 2. It must be really bad for Karen Reed. This is trial number 2. Maybe she's already been convicted of something. Or it's trial number 2, meaning the Commonwealth failed, so therefore we shouldn't even be here, right? Because that's not what the rules say. To me, it sure feels like reasonable doubt if you can't get jurors to convict. But that's not what a mistrial is, right? That's a not guilty verdict. So it's not seen as relevant. And we also don't want the jury to think, oh, there was another jury that was hung and couldn't come to a decision. Why should we come to a decision? Let's just have a stalemate and get out of here. I don't want this to be on me. I don't want the blood on my hands, right? So there's a lot of things we want to avoid that aren't necessarily probative of them knowing that information. Richard White, good demo, I guess, but this is a virtual phone. No confirmation of physical phone and iOS version used, or am I lost? Richard, you sound about as lost as I am. Those are very good points. I don't know. These lawyers got to explain it to me. All right, let's get to McCabe. They get to her family background. They get to the fact that basically John O'Keefe was her best friend. They talk about meeting up at the waterfall. She had 2 to 3 drinks, wasn't affected at all. John O'Keefe and Karen Reed showed up. She was happy to see them. She loved John, liked Karen. Karen and Jen have MS, so they bonded over that. She identified some people at the video at the waterfall. They're all going to Fairview afterwards. She gives John O'Keefe's directions. She tries to talk about Bella, but there's a timely objection, or I should say Bella's mom, I think. Timely objection didn't come in. Good job by the defense and good decision by Judge Cannoni. The music video, It's Raining Men, got played that night in the house. You know, haha, it was so funny. Everyone in the house in a great mood, celebratory, no fighting, no violence, nothing, which I think is smart things to point out by John O'Keefe. She was expecting them to come. She saw the car outside. The blinds were drawn, but you could see through the glass door. The car was gone. She didn't look outside. When Brennan's like, why didn't you go out and look? She's like, why would I? And then she kind of giggled. Will the jury look negatively on that? I don't know. She left around 1:30, 1:45. Higgins left before her. Again, no fighting. When you left, this is a question by Brennan. Did anything cause your heart to race or your heartbeat to race? We know where that's going. She says no. They were going to drop off Julie and Sarah, and the weather was getting worse. And then a little, if this is where the acting classes come up, this definitely, as a lawyer, makes me think certain things, when they say certain things, doesn't make me think it's prepped. The way she moves and the questions that are asked here absolutely makes me think she was prepped for this moment right here, for a time such as this.
Sure.
So both of the young women were in the backseat?
Yes.
Was there any conversation when you got into the car?
We got in the car and they were teasing me
Why were they teasing you?
because I had like bread and maybe peanut butter in my car.
Why did you have bread and peanut butter in your car?
I had my niece for the week, and I was dragging her like to all my kids' sporting events. So we'd go from like one game to another game to a practice. So sometimes instead of always giving her McDonald's or Dunkin' Donuts, I'd try to throw her a peanut butter sandwich.
And they were making fun of you?
Yeah.
As the car backs out of the driveway, tell us what you're doing.
I'm talking to the girls.
You just moved your head.
Yes.
Does that mean anything?
Yes.
Tell us.
You just moved your head. Does that mean anything? Yes. Thank you for asking. Why, thank you for asking, Mr. Brennan.
So they were both sitting behind me. So I was like turning and, chatting and talking.
After your husband pulls out of the driveway, do you start to drive home?
Yes.
If the house is on my right.
So Barry, you're right. And we as lawyers don't want that. So that's why they're not going to know about it.
And you're driving. Are you in the passenger seat closest to the house or furthest away?
Passenger seat closest.
So you're driving, if you look at a picture of the house, you would be driving from right to left?
Yes.
So as you start to drive, or your husband starts to drive the car, what direction are you looking in, if you remember?
The back seat.
Did you drive by the front of the house, do you know?
We pulled out of the driveway and went up Chapman.
Okay.
Shoot, I forgot to mention my point of playing Alessi's redirect. Sorry, or recross. I don't think I said this. So Alessi pointed out, and it was a good job on recross, that this happened after you changed it, because you changed it, and Axiom still shows the same thing. I think I said that. I can't remember. There was something I wanted to mention at the end of yesterday's episode that I forgot as well. My brain's going, a million miles a minute. This is actually a good time to answer this question. Between all these cases, plus your own, and just living your personal life, do you ever sleep? Keep up the good work. I appreciate the breakdown and the coverage. Sometimes it's not that hard. And with a calendar and a schedule, and you stick to it, but when there's a trial going on every day with nightly recaps, it's a lot tougher. It is a lot tougher listening to it all day, coming home and doing this. And I want to get to them. That's why I've been doing them earlier. My life has changed since 4 years ago when I was doing Johnny Depp. My kids are older. They don't go to bed as early. They've got sports and other things they're doing every night. So this timing seems to work better than late at night. But I don't know. It's really fun. I enjoy doing it. And I've got an awesome team that helps me do it. So, but my brain still farts plenty. Not quite done with this clip yet.
And your husband and you passed by the front of the house?
Yes.
Did you pass by the flagpole?
Yes.
Were you looking at the flagpole?
No.
And how dark was it at that point?
It was dark.
Snow?
Yes.
As you're passing the flagpole, do you hear or see anything remarkable?
No, I'm not really paying attention. I'm just chatting to the girls, and Matt's just focusing on driving.
When you're talking to the girls and they're making fun of you, what's the mood in the car?
We're all laughing and joking.
Where do you go next?
We drive Julie Nagel home.
After you drop off Miss Nagel, where do you go?
We drop off Sarah Levinson.
Is the weather constant?
Yes.
After
All right, so that's where they drove. Then when she goes home, she goes to bed. She used her phone, texted some friends, Googled the basketball game, Googled the basketball team that her daughter might go on, then put the phone down, went to sleep. She gets a call early in the morning. She was groggy. She could tell Kaylee was upset. She started to try to figure out what was going on. Karen Reed screaming things. She mentions, which again was totally inappropriate, should have been objected to, should have been struck. I don't know. Maybe John and Karen got in a fight. Totally inappropriate. Speculation, not even saying it did happen, just should never come in, but that's just an example of a witness trying to force some stuff out there. And then she starts to explain how Karen Reed, shows her or talks about the cracked taillight for the first time.
Watch the form.
Okay. What did you remember? What came to mind
Watch the form for the 50th time.
after you spoke to your husband about your memory from earlier that evening?
The minute he said it, I remember seeing the SUV and then all the text messages that I had and the phone conversation with John.
So after the defendant spoke to you and said she had left the defendant at the waterfall and you had time to think about your memories, did you react or do anything with that?
Yes, I believe I called Kaylee back.
Why did you call Kaylee?
I didn't have Miss Reed's phone number.
When you called Kaylee back, did you speak to anybody?
Yes, I believe Kaylee and then Miss Reed.
When you first spoke to Kaylee, could you hear anything other than Kaylee?
The screaming,
Was it any different or was it similar to the first time you spoke by phone?
similar to the first time.
Regarding the demeanor or intensity, had it changed at all?
Not at all.
You mentioned the first time that you had that phone.
And again, talking a lot about what Karen Reed said. That's a big part, obviously, of the Commonwealth's case. To be honest, doesn't matter if the jury knew about trial one when 95% have heard of it. I think it does. Again, we can agree to disagree on that. A couple other things that came up in this, which some good questions here, Susie. Jen McCabe stated she called so many people that night, but never called the owners of 34 Fairview. Isn't that her sister's house? Not only was it her sister's house, but when you see the cracked tail light, you're saying Karen Reed said, did I hit him? I could have hit him. I hit him. Well, where's the last time you saw her car? Those are logical questions. Why would you not call? You had their number. You knew where that was. I think that's a fair question. Jen, I cannot believe the Commonwealth went with the didn't take her shoes off going in John's house argument again. Is it just me or is that not the biggest reach? I just don't understand what that proves. I don't understand what that proves. Right? Oh, she didn't take her shoes off, so she must hate John enough to end his life. After a conspiracy and friend dead, you're not Googling your daughter's basketball game. I agree. I 100% agree. That doesn't make sense. That's totally illogical. And that's what Brennan's going to try to prove with the Apple Health data as well. And also, I think to the jury, if you can really make them believe John O'Keefe is one of her best friends and closest confidants, would she really do this and cover it up? The Warthog, did you mention the rock on the jury view? I didn't. I forgot to. I meant to mention it off the top. Judge Cannoni's like, disregard that. Both lawyers agree. If that would have said, free Karen Reed on it, or the Alberts did this or something like that, you think there would have been a little more of investigation or scolding? My guess is yes. Gina G, is Jackson has gone quiet after telling off? I don't think so. I think he's just waiting for his next turn because they're all taking turns at this point.
Time that you had that phone call, the defendant was screaming your name.
Yes.
Jen. Was she saying your name in the second call or was it just general screaming?
My name. And then when she got on the phone, I had told her, Karen, I saw you guys outside of my sister's house. And then she told me she didn't remember being there. And then she went on to say, she started saying, could I have hit him? Did I hit him? And then she just was just all over the place, like screaming my name, screaming so many different things. She was hard to follow or understand.
When she was saying to you, did I hit him? Could have I?
So again, she's going to make sure she gets certain things in. And then even when it doesn't really track, right? When it doesn't really make sense, she's like, she said this and she said, oh, you were so drunk, you could have hit anything. Carrie said to Karen, which again, should not have come in. That should have been, that was objected to and still allowed. We're going to listen to a little bit of that. But she tries to make sure to force in the certain things, which the Commonwealth needs to be able to argue. Reality, that's wild. I did not know that. They don't need to understand the definition of impeachment. The point is they need to get the fact that this is inconsistent. This is not what you said before. And there are jury instructions about witness credibility. Can you believe them? Was their testimony consistent with what other witnesses are testifying to and even some of their prior statements?
I hit him. Was that before or after you informed her that you had seen her out front of your sister's house?
It was after I told her that. She also informed me that she had cracked her taillight.
In that conversation, she told you that?
And then she's like, oh, and she also said she cracked her taillight.
In one of the conversations I had with her in my bedroom, yes.
And you have to get that out. If you're the Commonwealth and you're Hank Brennan, and that's what she says, that's important. That's how you're proving your case. You have to get it out. I don't think it was the most natural explanation, but you got it out. Meatballs also thought she did better this time around. Again, like I already said, I tend to agree with that. Karen really wanted to go to Fairview. Carrie wanted to go to Meadows. Carrie took charge. Carrie was definitely in charge. Then we go back to the, tail light, missing pieces, and her saying something I thought was completely inadmissible. There was an objection by the defense. The judge let it in. To me, this is the type of stuff that's really damning if a jury picks up on it and believes it.
I told Kaylee that I was going to go out with them and I was going to find John. And I promised her that everything would be okay.
At some point you left Kaylee?
Yes.
Where did you go?
I went back downstairs and then we went out to look for John.
Before you left John's house that morning, did the defendant show you anything?
Yes. When we were out in the driveway, I had thought it was when we went in, but I think it might have been when we came out. But regardless, at one point when we were in the driveway at Meadows, Karen showed myself and Kerry Roberts the cracked taillight.
Did you or Miss?
She showed them the cracked taillight, and she saw the piece sticking out that was going to catch their jacket. Perfect. Exactly like what Kerry Roberts said, almost like they wrote a timeline down together, which again, the defense has planted that now in our heads because they talk about the timeline and getting it together and sharing stories and how those stories too can become one, like what is their name? Oh gosh, Spice Girls. Was that two become one? Whatever. Like they said, and your stories can really morph into one. Lori, I don't think he was wearing an Apple Watch, right? I think they got all this from his phone. Robin, it's funny you mentioned this. So I had an expert in federal court one time where we struck 90% of his testimony because the judge struck his paper that was peer reviewed by him and like a professor when he was in college. So that matters. How was Karen telling Jen her taillight is cracked while still at the house with the niece? She hadn't even been out to look for John yet. Wouldn't the peanut butter and jelly have been frozen driving around in Massachusetts in January? Practice story, in my opinion. I have no idea. I've never driven around with peanut butter in my trunk when it's frozen outside. It would be melted and be water here in Florida most of the year.
Miss Roberts get close to the taillight at that point?
Yes, we walked over and the taillight was missing pieces.
Did Miss Roberts have any comment about it?
Yes, Miss Roberts.
So she had a comment.
What was Miss Roberts' demeanor at that point?
She was frustrated with Karen, had said that, had said that Karen basically was telling her to shut up. You were so drunk. You could have hit anything last night. And then
that's the type of crap that should not come in. You're so drunk. You could have hit anything last night. That is hearsay. It is speculation. It is prejudicial. It is not probative. Basically, everything you could ever do to get something to not be allowed in a trial that fits for, but there it is. And the defense even objected. That's an appellate issue to me, frankly. I think that's a bigger appellate issue than a lot of things people are like, oh, that's such an appellate issue. Because that's horrible. You can't say stuff like that, and they objected. Megan, I can look into it. Was there anything else here? A little bit more.
Kerry, I remember just thinking, all right, let's go. And I remember Kerry thinking, oh,
Well,
someone's
let me
going to
not
get,
ask you what Kerry-
sorry.
We don't want to think what somebody thought.
Okay.
I want to know what you
We don't want to think what somebody thought. Just say what they said, because that's what just happened. Is there anything else we need to talk about? Point out a piece sticking out, force them to go to Fairview. We're going to have a lot more Jen McCabe tomorrow, but now we're going to switch gears a little bit. Let me see if we have any other Jen McCabe questions. Amy P. Peter, thanks for all you do. Love your channel. Why didn't Bev let Whiffen share his own phone results from his drive to Fairview? I don't know. And the Commonwealth objected. The defense wanted to get into it, and the judge didn't allow it. I was wondering why. Maybe they don't know what it was going to show. Like if the defense was going to walk into that, I would trust my expert. Like, hey, good luck. That guy's an expert. He should be able to handle this. The shoe thing, they're trying to prove she already knew he was dead. If he was alive, maybe slept at a friend's, she'd abide by his strict rule. Like the other two didn't know he was dead. I feel like they have not argued she knew he was dead, right? I mean, I guess they said she knew exactly where he would be, but a lot of it is like she hit him and didn't even know what happened. I don't know. Maybe you're right. I think Jen did well, and the jury will go home with a good image of her for now. I agree. I think she did well. I'm in Spain, communication blackout for 24 hours. I'm trying to catch up. Anything Ben said in Bev's court about Turtle Boy's affidavit about Jen, CL, etc. since it's filing, I have not seen anything about that. I have not. Karen keeps saying everything in threes, very specific and very weird. Like, is that a real thing? Do people, like, in traumatic situations start saying things in three? Sue Tapp, one of my biggest questions for Jen, when they found John O'Keefe, why didn't Jen go to her sister and brother-in-law, who was a first responder, and say, hey, did something happen in there? Did John ever come inside? Did he slip and fall? Because they're all acting like at the scene, they didn't think Karen hit him. They would have never thought that about their friend Karen Reed. All right, let's get to ARCCA. Brennan gets up. He says they need to be precluded from testifying on anything new and from testifying from their old opinions. I was like, what? I thought he said, we don't care. We want ARCCA to be able to testify because that's fair to the defense. We want them to be able to testify. Well, that has, in fact, changed. And he basically made Wolf look like a liar and a perjurer and a snake. We learned more from Rentschler in 5 minutes than we did from Wolf in an hour and 45 minutes. They violated the court order. Wolf destroyed intentionally 100 text messages. They violated the sequestration order, the court's order to turn those things over. It is so unfair in the last trial. We can't let it happen again in this trial. Basically hiding things and lying to us about their discussions. So before I was a lawyer, I would ask my dad, is it weird going in, making arguments you know you're going to lose? Like, and you pound the table, you go hard, you believe it with all your might. He's like, no, you just kind of get used to it. You make the argument, you fight the fight. If you lose, you lose. And I think that's what Hank Brennan was doing here because he had to know he was going to lose. If I knew he was going to lose, he had to know he was going to lose, right? So let's listen to kind of his final argument and the exchange between Alessi and the judge. I'm going to slow this down to normal speed. We're also going to look up a rule here in a second. I've got about 10 minutes max left, and we're going to dig in here on ARCCA these last 10 minutes.
ARCCA witnesses. So now going into this trial, even Dr. Rentschler admitted that an expert should have time, in their opinion, a month or more, to review the raw materials. It's not enough simply to have a report, as Attorney Alessi preached during his argument. We should have the opportunity to go through the raw data, the history, the videos, determine whether there's any failed testing. We don't have that benefit. And so my position has changed, that those early opinions should not come in because we have no ability to fairly cross-examine. As for the new opinions,
no ability to fairly cross-examine. Come on. No ability to fairly cross-examine?
Report may not be done until May 7th. We are in the middle of trial. Concedingly by the defense, or at least their witnesses, it takes a month to go.
I got to bump it up. Sorry, it's just so slow.
Go through the discovery. When I filed my motion on the eve of trial that we would be unable to prepare or we would want a continuance in this case, I appreciate why this case wasn't continued. But I knew, given our scheduling, our experts will not be able to look at this material. Our expert is away until after the first week of May. He is going to be testifying shortly after. He will have no ability to digest this enormous amount of materials, vet whether it's accurate or not.
That's actually a good argument, to limit the future stuff, but not when the judge is going to remedy that and give you more time if you need it. Those are her options. Don't let him testify to it or give you more time. You're not going to step on a defense because the constitutional rights, it's kind of important. So she'll give you more time, which she's going to do. By the way, we're over an hour overtime. You know what that means? Everybody hit that like button. Hit that. Let's get this one to 15,000 likes. Everybody hit the like button.
Conduct tests to combat it if he thinks that it's inaccurate or unfair. And so the discovery violations, regardless of the state of mind, are upon the defendant. There is no exception that you used ARCCA witnesses. There is no exception that you hired somebody that used to be under a federal protective order. They chose them, and I would suggest it seems strategically. When we noticed we'd have new experts in October.
He really wishes they would have picked other experts.
The defense from past experience, and probably other experience, but we know from this case, knows the process. They would have to file a TUI letter and wait for a response. And yet they waited until February to seek permission, which then extended their permission past February into March. And then they didn't even start the review until late March. And so it's fundamentally unfair. We should not be placed in the position of cross-examining experts without the fair ability, as any petition, defendant, Commonwealth, any participant would have in a case to consider and then to rebut. And so for that reason, I ask you to exclude both the new opinions and new testing, and also to exclude the earlier opinions that we will never at this point receive the proper discovery with to prepare.
All right, thank you. Mr. Alessi, I only have one question for you.
All right. So now we get to her questions for the defense. And anytime a judge limits what a lawyer is allowed to do, usually that means you're going to win. You don't like it. You hate it. Lawyers want to say their piece. They want to make their argument. But usually it is a good sign.
So would you stand, please? You're arguing this, right? This was your motion. So my question is, how do I reconcile the fact that 100 text messages were deleted by counsel? And we heard yesterday counsel's preferred method of dealing with Dr. Wolf was via Signal. How do we reconcile that with the Massachusetts Rules of Professional Conduct 1.15? I don't see how you reconcile that, where all correspondence related to the matter, whether in physical or electronic form, must be saved for 10 years minimum.
Let's take a look here at Rules of Professional Conduct 1.15, safekeeping property. Do you guys actually want to see it, or you want me to just read it to you? Let's put it on the screen here real quick. Just so you can see what this rule is actually about. Definitions: trust property, trust account, segregation of trust property. If you're not aware, lawyers in the trust account is a big thing. You have client's money, you have your money, you can't commingle them. You can't use one client's money to pay bill on another client's case. You've got to keep all that separate. There are all sorts of rules about the trust account. That's mostly what this is talking about. Delivery of trust property to client, accounting, operational requirements for trust accounts, required account and records, trust account records. I mean, these are the rules. There's tons of rules on trust account, what you can do. Interest on a lawyer's trust account. We can't take the interest that it's building. There's just all sorts of rules that this is with the trust account. But then we get down to the comment section, okay? And comment 17 says, the records associated with unclaimed and unidentified funds may be necessary to a later determination of ownership of those funds pursuant to Rule 1.15I, prohibits a lawyer who has transferred such funds from destroying the related client file or files for up to 10 years. I think there was one other time when it talks about 10 years. I thought there was one other time when it talks about 10 years from what she's reading. But from what I can see, Rule 1.15 from the Massachusetts Rules of Professional Conduct, unless there's another rule I'm not seeing, it is only dealing with client property. And even the way she read it, it certainly sounded like it was dealing with client files, client communication. You know what it wasn't talking about? Expert communication. I've actually done a lot of research since finding out about Signal to see, is it appropriate, is it not? I'm going to bring it up in the Civil Rules Committee and see, how do we want to deal with this? Because if there's nothing wrong with it, why can't we use that to talk about with experts? I haven't been able to find any rules of professional conduct that don't allow it. I've never used it before. I'm going to keep digging. I'm going to keep asking. I'm going to call the ethics hotline in Florida and talk about it and see, is there anything wrong with using this with experts? Because I can't seem to find it. And my guess is neither can Judge Cannoni and neither can Hank Brennan, or they would have actually cited a real rule that outlaws that. Instead, they absolutely did not cite a rule that says that. And she knows it, and she shouldn't have said it. But I had a feeling a public scolding was coming. And guess what? Here it is. Here is the public scolding. And it was a complete swing and a miss. It was embarrassing. She shouldn't have done it. She makes the right decision, and props for that. She's going to allow, we're going to listen to her allow ARCCA to testify to what they testified to before, obviously, and what they testified to in their new testing that they're going to do until May 7th. Absolutely the right decision. Kudos to Judge Cannoni for making the right decision. Thank you for doing the right thing. But wow, what a misstep. What a waste of time to even say this, to ask Alessi this question. There was no purpose to it at all. People on Twitter were like, hey, is there any legal ramifications or purpose or anything for asking this question? Zero. She even admits that she knows that that is not what this rule stands for. She knows it. She shouldn't have done it. And to me, if you don't want people to call you biased and you don't want people to get frustrated with what you're saying publicly, don't do stuff like this. Make the right decision that every lawyer looking at this case knew. It was a very easy decision. She did it. She made the right decision. That should have been the headline for today. Judge Cannoni You call her biased, but she keeps making the right decision. She's allowing the defense to put on their case. That should have been the headline because she did do the right thing. But oh boy, did it feel like it was through gritted teeth. And she goes even further here.
How do you reconcile that? How do I reconcile that?
Should I go to the podium?
Right there, and I expect a short answer.
Alessi's like, can I go to the podium to answer this? She's like, no, do it from there and make it short, which again, to me, you're always sweating and you're nervous in the moment, but usually that means you've won.
Short answer, Your Honor, is the rule that you're citing has absolutely no applicability to this proceeding. Can I finish my answer, Your Honor?
Right ahead.
Has no
He's like, you said I could answer. Let me answer.
applicability. That rule with this proceeding. Can I finish my answer, Your Honor?
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. That's a different body, but
If you agree, why did you say it? Why was that your one question? If you agree with what he's saying, why is that your one question for Mr. Alessi?
I'm asking you how I reconcile that when I'm trying to figure this out. Mr. Alessi, you know what? You're going to win this, so why don't you just let me make my ruling, okay? So,
Like every experienced defense lawyer, Alessi's like, I'll see myself out. He sits down immediately, and now we get the answer.
I understand there have been repeated violations of the reciprocal discovery orders, and
Are you saying the signal stuff or the deleted text message is a violation? And if it is, explain why, please.
my orders, repeated and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's argument, completely the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So,
Thank you. I think she believes that, and I hope she keeps making decisions off of that. And I think she has made some decisions based on that.
I'm going to allow the ARCCA witnesses to testify. I am going to allow what I expect to be a very robust cross-examination. And I'm going to allow them to testify to everything that they said up until yesterday. So you'll get the report May 7th. And I know that's late.
Literally everything. Everything the defense wants them to testify to, they're going to be able to testify to it.
And if you need anything as a result of that being late, I'll hear you on whatever motion you have. But that's where we stand. And I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct, and no more nonsense. Let's just try this case. All right, that's it.
Explain. You just admitted the rule has nothing to do with what you said. So explain the violations, explain the nonsense, explain what's going to change. Because you can't produce records that don't exist. We've heard prosecutors say that in so many cases, right? If it doesn't exist, Judge, how am I supposed to present it? Can we ask Brennan if he was friendly with Whiffen? Oh, Whiffen. All right, I got to burn through some of these questions here. Azam, no jury during ARCCA hearing. When Hank Brennan said, I think back when Dr. Wolf said he didn't recall, can the defense do the same thing on cross, or is it badgering? It's probably inappropriate in the way that Brennan said it, in like a sarcastic way. Lane, the judge is so biased, other than appeal, any other recourse for the defense to complain about this? No, she let you have your witness. You go ahead and take your witness. Did I get the robust cross already?
That's it. I'll see you tomorrow.
All right, the court, please.
We got some questions about the robust cross. Brennan's robust cross of ARCCA may just open the door for the defense to go into the DOJ engaging ARCCA. I would be shocked if anything Hank Brennan said or asked made this judge allow the defense to say, actually, the feds hired ARCCA. I would be shocked. I think they should be able to open the door. I don't think they will. Do you think the defense should drop that ARCCA were hired by someone else and just have them focus on credentials and experience, losing the confusion? I would bring it up, but my dad disagrees. He would just drop that part. So there's some differences of opinion there. Nicole, based on the judge's comment about a robust cross for ARCCA, do you think Brennan will be allowed to be as aggressive as he was yesterday? He may be allowed. I think it would be a mistake to do that in front of the jury. Sandra, but why did she delete only the first search at 2:27 and leave the other queries with typos 6 a.m.? Was she covering the fact that she knew she'd screwed up at 2:27? He says it was inadvertent and nothing she did purposely. That's what Ian Whiffen said. Reality, was carried their orange he roped in by the McAlberts, and when will one of them fold and tell the truth to save their butts? Or do you think they won't go after other suspects? I definitely think they're not going to go after other suspects. I think once you present a case against a defendant, it's really hard to change course there. Robin, Peter, have you ever had a judge come at you for something out of your control and hit back with a clean, legal mic drop like Alessi, total masterclass? Yes. And there's nothing you can do if it's out of your control. Jay Coop, what do you think of the Commonwealth changing their theory 4 times? First time it was 3 p.m., 3-point turn. I'm interested to see how the defense uses that. Josh H., my QKR was frantically, my question, Karen Reed was frantically looking for John O'Keefe, and they were all at your relative's house. Would you not call them to ask if John O'Keefe was there? That's a good point. Anna, BA is first responder. Many more blankets there at their house. Find it suspect that they head straight into their house for help. Your thoughts? If it was my sister's house, I would bang through. I'd know the code. I'd type in the code, go in there and get what I could to help my friend. Peter, can you give a shout out to my girlfriend, Stacia? She just completed her paralegal certificate. So proud. That's awesome. That's awesome, Stacia. Congratulations. Meatball Morsi, it's funny Hank doesn't realize Jen and Carrie contradict each other. Carrie said Jen wanted to go to 34 Fairview, not Karen. I agree. That was an inconsistency. Greg, there's a lot of speculation that Dr. Wolf mentioning the feds watching spooked her. Do you think there's potential for that? I don't. I think we all know the feds are watching. Julie, why would you have to reconcile something like that doesn't apply? Stupid question. Where's the ambush, though? Yeah, not coming. Z. McCarthy, how is robust cross of ARCCA bias okay, yet she won't allow the truth regarding DOJ hiring them? Yes, the rules of evidence. The rules of evidence. Unfortunately, sometimes it feels unfair. How do you reconcile that the video from the Sally Port never got turned over? She doesn't. She's not even going to try. Cannoni in the Peggy McGee trial was fair. We know she can do it, just not this case. Any thoughts on Bev doing this when she says they were ambushed and after her statute of implication that she knows the trial is being watched by the feds? I don't think that's affecting her, but I don't know. DA's private emails to Karen and Aiden Judge and 30-day auto delete isn't violation, but deleted messages that correspond with tickets and calendar is, I get it, hypocrisy. All right, I've got to run. Please hit that like button. I ran over. I'm late. I'm going on NBC 10 like right now, unless they told me I'm too late and I can't do it. Love you all. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.